There is a legitimate concern that there is a double standard. If your name isn't Clinton or you're not part of the powerful elite, that Lady Justice will act differently. We'll now recognize the gentleman from South Carolina, Mr. Gowdy, for 5 minutes.
Good morning, Director Comey. Secretary Clinton said she never sent or received any classified information over her private email. Was that true?
Our investigation found that there was classified information sent.
So it was not true?
Right. That's what I said.
Okay. Well, I'm looking for a little shorter answer, so you and I are not here quite as long. Secretary Clinton said there was nothing marked classified on her emails, either sent or received. Was that true?
That's not true. There were a small number of portion markings on, I think, 3 of the documents.
Secretary Clinton said, I did not email any classified material to anyone on my email. There is no classified material. Was that true?
There was classified material emailed.
Secretary Clinton said she used just one device. Was that true?
She used multiple devices during the 4 years of her term as Secretary of State.
Secretary Clinton said all work-related emails were returned to the State Department. Was that true?
No, we found work-related emails, thousands, that were not returned.
Secretary Clinton said neither she nor anyone else deleted work-related emails from her personal account. Was that true?
That's a harder one to answer. We found traces of work-related emails on devices or in Slack space, whether they were deleted or whether when a server was changed out something happened to them. There's no doubt that there were work-related emails that were removed electronically from the email system.
Secretary Clinton said her lawyers read every one of the emails and were overly inclusive. Did her lawyers read the email content individually?
No.
Well, in the interest of time, and because I have a plane to catch tomorrow afternoon, I'm not going to go through any more of the false statements, but I am going to ask you to put on your old hat. False exculpatory statements, they are used for what?
Well, either for a substantive prosecution or for evidence of intent in a criminal prosecution.
Exactly. Intent and consciousness of guilt, right? Is that right?
Right.
Consciousness of guilt and intent. Mm-hmm. In your old job, you would prove intent, as you just referenced, by showing the jury evidence of a complex scheme that was designed for the very purpose of concealing the public record. And you would be arguing, in addition to concealment, the destruction that you and I just talked about, or certainly the failure to preserve. You would argue all of that under the heading of content. You would also be arguing the pervasiveness of the scheme, when it started, when it ended, and the number of emails, whether they were originally classified or up-classified. You would argue all of that under the heading of intent. You would also probably, under common scheme or plan, argue the burn bags of daily calendar entries or the missing daily calendar entries as a common scheme or plan to conceal. 2 days ago, Director, you said a reasonable person in her position should have known a private email was no place to send and receive classified information. You're right, an average person does know not to do that. This is no average person. This is a former First Lady, a former United States Senator, and a former Secretary of State that the President now contends is the most competent, qualified person to be President since Jefferson. He didn't say that in 08, but he says it now. She affirmatively rejected efforts to give her a state.gov account. She kept these private emails for almost 2 years and only turned them over to Congress because we found out she had a private email account. So you have a rogue email system set up before she took the oath of office, thousands of what we now know to be classified emails, some of which were classified at the time. One of her more frequent email comrades was in fact hacked, and you don't know whether or not she was. And this scheme took place over a long period of time and resulted in the destruction of public records. And yet you say there is insufficient evidence of intent. You say she was extremely careless, but not intentionally so. You and I both know intent is really difficult to prove. Very rarely do defendants announce, on this date, I intend to break this criminal code section. Just to put everyone on notice, I am going to break the law on this date. It never happens that way. You have to do it with circumstantial evidence. Or if you're Congress and you realize how difficult it is to prove specific intent, you will formulate a statute that allows for gross negligence. My time is out, but this is really important. You mentioned there's no precedent for criminal prosecution. My fear is there still isn't. There's nothing to keep a future Secretary of State or President from this exact same email scheme or their staff. And my real fear is this. It's what the chairman touched upon. This double-track justice system that is rightly or wrongly perceived in this country. That if you are a private in the Army and you email yourself classified information, you will be kicked out. But if you are Hillary Clinton and you seek a promotion to Commander-in-Chief, you will not be. So what I hope you can do today is help the average person, the reasonable person you made reference to, the reasonable person understand why she appears to be treated differently than the rest of us would be. With that, I would yield back.
We'll now recognize the gentleman from Virginia, Mr. Connolly, for 5 minutes.
Thank you, and welcome, Director Comey. And although our politics are different, I gather you're a Republican. Is that correct?
I have been registered Republican for most of my adult life.
All right.
I'm not registered any longer.
We don't register by party in Virginia, but many have suspected my politics as being Democratic. And I thank you for your integrity. As my colleague said, and I said in my opening statement, your career has been characterized as speaking truth to power. And you're doing it again today. Just to set the context, Director Comey, not that you're unaware of this, today's hearing is political theater. There's not even the pretense of trying to get at the truth. This is a desperate attempt under an extraordinary set of circumstances, an emergency hearing. I don't know what the emergency is other than one side is about to nominate somebody who is a pathological narcissist who, you know, is talking about banning Muslims and Mexicans crossing the border who are all rapists and women who are pigs, and terrified at the prospect of the consequences of that in the election. So let's grab onto whatever we can to discredit or try to discredit the other nominee, putative nominee. And you took away their only hope. And so the theater today is actually trying to discredit you. Subtly, in some cases. My friend from South Carolina uses big words like exculpatory and kind of goes through what a prosecutor would do. The insinuation being, you didn't do your job. My friend from Wyoming is apparently flooded with citizens in her home state who are reading the statute that governs classification. A lot of time on the hands back there, I guess, but yeah, this is all designed to discredit your finding. Now, the FBI interviewed Secretary Clinton, is that correct?
Yes.
Did she lie to the FBI in that interview?
I have no basis for concluding that she was untruthful with us.
And is it a crime to lie to the FBI?
Yes, it is.
David Petraeus did lie to the FBI.
Yes. Yes.
And he was prosecuted for that. Oh, well, could have been.
Could have been, was not for that.
Right. That's always a judgment call.
Correct.
Was she evasive?
I don't think the agents assessed she was evasive.
How many emails are we talking about, total, universe, that were examined by your team?
Tens of thousands.
Tens of thousands. And how many are in a questionable category that maybe coulda, shoulda been looked at more carefully because there could be some element of classification? Apparently my friend from North Carolina assumes we're all intimately familiar with the fact that if a C appears, it means a classification, though there seems to be some dispute about that because the State Department, as I understand it, has actually said some of those were improperly marked and shouldn't have had the C. Aware of that?
Yes.
Yes. So could it be that in her 100-trip, 4 years, 100 overseas trips to 100 countries, as Secretary of State trying to restore U.S. credibility that had been destroyed in the previous 8 years overseas, and tens of thousands of email communications, not including phone calls and classified conversation and SCIFs and the like, that maybe the small percentage of emails shouldn't pay as much attention to them as maybe, in retrospect, one would hope she would have. Is that a fair conclusion? Could that be a fair conclusion?
I don't usually deal in maybes. It's possible.
Well, you do deal in distinguishing between willful and inadvertent.
Sure.
And in this case, you concluded it has to be in the latter category. It wasn't willful.
We concluded there was not adequate evidence of willful conduct.
Right. So there's no obfuscation here, unlike the Petraeus case. And there's no evasion. There's no lying. There's no willful intent to compromise classified material, despite the insinuations of my friends on the other side of the aisle. And the only hope left in this political theater is to discredit you and your team in the hopes that, therefore, you won't have credibility and we can revisit this monstrous crime of using a private server, that server being the server of the former President of the United States that maybe Mrs. Clinton thought would be more secure than the leaky system at the State Department. I yield back.